Good morning and welcome to the 2021 Forum on Language and the Law, hosted jointly by the Department of Linguistics and the S.J. Quinney College of Law at the University of Utah. My name is Scott Jarvis and I'm the chair of the Department of Linguistics here at the University of Utah. I want to thank our esteemed speakers for being willing to share their knowledge and skills with us, and I want to thank all of you for joining us. I'm confident that you'll learn a lot of things today that are not only intellectually stimulating, but also useful and timely. Special thanks to our two sponsors, the College of Humanities at the University of Utah, under the leadership of Dean Stuart Culver, and the Tanner Humanities Center, whose current director is Erica George, the Samuel D. Thurman Professor of Law at the University of Utah's S.J. Quinney College of Law. I also want to thank Karen Marr Schaefer and Chantel Arise of the Department of Linguistics, as well as Chris Monty, Charlie Stewart, and Spencer Cope from the S.J. Quinney College of Law events team for all of the excellent work that they've already done and are continuing to do to make this a successful event. I am especially grateful to Dean Elizabeth Kronk-Warner of the S.J. Quinney College of Law, who's been a wonderful partner on this annual event. Dean Kronk-Warner holds a JD from the University of Michigan and is a nationally recognized expert in the intersection of environmental and Indian law. We will now be privileged to hear from her as she officially opens the 2021 Forum on Language and the Law. Dean Kronk-Warner, the floor is yours.
Wonderful. Thank you, Dr. Jarvis. And it is really a privilege and honor to be part of hosting today's conference. I echo what Dr. Jarvis said in terms of all of the excellent content that we have for you today. And I think you're going to find it really interesting and enjoyable. As was mentioned, my name is Elizabeth Kronk-Warner. My pronouns are she, hers. And I like to start off any event by acknowledging that the University of Utah acknowledges that this land, I'm currently coming to you from the Salt Lake Valley, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples in their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. And so it seems particularly appropriate that we should be together today to embark on this important community outreach activity, looking at this issue of the intersection of law and language. So one of the most treasured rights of society are really enshrined in law. And of course, law is encoded in language. So there's an important intersection there. Language is the medium through which laws are created, enacted, promulgated, interpreted, and enforced. Legal professionals deal with the language of law every day and become language experts in the process. Nevertheless, the complexities of language oftentimes make it useful, if not necessary, to partner with colleagues in other disciplines who specialize in the science of language. And so that, again, is why I'm so excited that we have this excellent conference today to look at that intersection and how law and language interact. The speakers of today's Forum on Language and Law represent this type of valuable partnership between the law and linguistics. They will show how current methods of linguistic analysis can profitably be put to use in critical areas of legal interpretation. And I am, for one, am very excited to learn everything that they have to share with us today. So with that, I'm going to turn it back over to Dr. Jarvis and say, Che Miigwech, thank you very much. And it's a pleasure to be part of today's conference. Dr. Jarvis?
Thank you, Dean Kronk-Warner. It's truly a privilege to hear from you. Thank you for opening us today. Members of the audience might be interested to know that this event is the third annual Forum on Language and the Law. The first one was held in 2018, and it dealt with non-native speakers in the American legal system. The second forum was held the following year, and its speakers included Judge Lynn Davis, law professor Janet Ainsworth, and the well-known forensic linguist Roger Schei. They spoke about a number of issues that they felt lawyers and legal professionals need to know about linguistics and about how expert linguistic analysis can greatly facilitate the proper application of the law. Because of COVID-19, we were not able to hold the Forum on Language and the Law last year, but fortunately, today's program includes everything that had been planned for last year and even more. The theme for today's forum is legal interpretation, and this includes an emphasis on corpus linguistic methods for determining original and ordinary meaning in statutes, contracts, trademark agreements, the Constitution, and other important documents. Whether your specialty is constitutional law, criminal law, civil law, or something entirely different, I believe that the information and methods you learn today will improve your ability to analyze and evaluate linguistic evidence as it relates to legal interpretation. At the very least, hopefully you'll know how to access the relevant resources when you need them. The speakers today include two linguists, a law professor, and a Utah Supreme Court justice. I'll introduce each of them briefly just before their individual presentations, but here's a quick overview. Our first speaker is the linguist Dr. Jesse Egbert of Northern Arizona University. He will offer insights into best practices in corpus-based linguistic research dealing with questions of original and ordinary meaning. Our second speaker, law professor Lawrence Solom of the University of Virginia, will discuss original and ordinary meaning from a legal perspective, focusing particularly on constitutional law. Our third speaker, linguistics professor Tammy Gales of Hofstra University, will highlight linguistic principles and methods while emphasizing her work on statutory interpretation in trademark cases. Finally, Associate Chief Justice Thomas R. Lee of the Utah Supreme Court will discuss the empirical methods he has used and advocated when dealing with questions of legal interpretation. Today's event is set up as a webinar, and as you can see on your screens, we currently have 129 participants, and I expect that to rise a little bit in the next few minutes. Because this is set up as a webinar, the speakers are not able to see or hear the audience, but they can see the questions and comments that you submit with the Q&A button at the bottom of your screen. You can submit questions or comments anytime, even during the presentations, and Karen Marsh Schaefer and I are going to monitor those questions and select as many of those as possible for the speakers to answer during the Q&A period after each talk. Each talk will last about 30 minutes, followed by about 10 minutes for questions and discussion. After the question and discussion period, we'll try to squeeze in a 5-minute break before the next talk. We're going to do our best to begin each talk at the scheduled time. And please stay with us until the end when Professor Bill Eggington will offer the closing remarks. He has a great deal of experience using the methods that will be presented today, and he has done so in dozens of both civil and criminal court cases in which he has served as an expert witness. I think you'll really benefit from hearing what he and each of our speakers has to say. I am now honored to introduce to you our first speaker. Dr. Jesse Egbert is Associate Professor of Applied Linguistics at Northern Arizona University, where he also received his PhD in Applied Linguistics in 2014. Jesse specializes in register variation, particularly in academic and online writing. His research also explores issues related to quantitative linguistic research, including corpus design and representativeness and methodological triangulation. He is the general editor of the international peer-reviewed journal Register Studies and has authored or edited 3 books and published more than 60 journal articles. He's been an active researcher in the area of statutory interpretation with related publications in the BYU Law Review and the Routledge Handbook of Corpus Approaches to Discourse Analysis. It is a great privilege to have him as one of our featured speakers today. The title of his talk is A Corpus Linguistic Approach to Quantifying Surplusage in Statutes. Jesse, the floor is now yours.
Thank you, Dr. Jarvis. So I'm honored to be here to talk a bit about research that I've been involved in related to statutory interpretation, and in particular today on the question of surplusage in statutes. I participated in this law and language forum a couple of years ago and became even more excited about the intersection of language and the law. I've been applying linguistics to legal questions for several years now, and I see a lot of potential for the future. We have a long way to go, but I think we've made some headway in trying to find ways to apply linguistic methods to legal questions. I want to make it clear today that my collaborating research on this project is Justice Tom Lee of the Utah Supreme Court. We've worked closely together for several years now on these issues, and I'm excited to share some things that we've been learning about surplusage and how linguistics can possibly help with those questions. So, brief outline, I'm going to talk about what I refer to as the statutory triad, and then I'll get into an overview of the linguistic canons of construction, in particular, the canon against surplusage, and talk about how linguistics can be used to quantify and identify surplusage in statutes. I'll show some results of research that I've been doing with Tom Lee on that question, and then make some comments at the end about the role of corpus linguistics in linguistic applications to legal questions. So first I want to start off by asking the question, why would a lawyer listen to a linguist? You may be asking yourselves that question today. What does a linguist have to offer to a lawyer, legal scholars, judges, or legal questions in general? I'll make a couple of remarks today, but I'm hoping by the end of the forum today, it'll become even more clear that there is a place for linguistics in legal interpretation. So first off, legal writing is a specialized register. A register is a variety of language associated with a particular situation of language use. And as such, it's different in important ways from other registers in the English language. I edit the journal Register Studies, and this journal engages with exactly these types of questions related to linguistic variation across specialized registers of English and any other of the world's languages. Second, corpus linguistics has been shown to be useful for legal questions, and there's a great deal of interest and excitement about the possible role of corpus linguistics in questions such as those in statutory interpretation. And there's a conference on law and corpus linguistics that's been hosted by the Brigham Young University Law School for several years now. Publications like this one that I co-authored this past year address questions of corpus linguistic methods, best practices, and how those can be applied in a variety of different linguistic questions. And then I, along with many other linguists, have been involved with legal scholars and lawyers and judges in trying to explore how linguistics and corpus linguistics can be useful for legal interpretation. And here's just a handful of those questions. Questions related to the original meaning of emoluments, questions about methods for testing ordinary meaning, and then looking at the canons of interpretation that I'll talk about today. So in short, I'm not sure that a lawyer should always listen to a linguist, but I think there are circumstances where it would be valuable for us to continue to explore this fruitful collaboration. Okay, so here's what I'm referring to as a statutory triad, for lack of a better term. It's just the obvious relationship between a legislative body, the writers of law that produce statutes, the statute itself, and the judiciary, who's tasked with interpreting the law. Obviously, the common denominator between these two groups of people, the legislative body and the judicial body, is the text itself, the text of the law. So the question is, does meaning lie in the writer of a text, or in the reader of a text, or in the text itself? And this is a question that has been of interest to linguists and literary scholars for centuries now. Where does meaning lie? And I think it's an important one for all of us to be asking when it comes to legal interpretation. Now, the simple answer may just be, well, to some extent, meaning lies in all three. However, when it comes time for the text of the law to be interpreted, I would argue that the text has an important role to play. So we could talk about textualism and proposivism and intentionalism and normativism and any of the other isms that exist in legal theory. But what I want to talk about today is the role of texts. So these legal theories and which one is most appropriate, that's not a linguistic question. It's not a question that linguists like me are concerned with. It's not that it's not an important question. Legal theory is critical to how we approach the language of the law, but linguists aren't going to be very helpful when it comes to those questions of legal theory. Where we can be helpful is this common denominator. The text of the law, the actual language in statutes and contracts and other legal documents is where the writers of law and the readers of law, the interpreters of law, share common ground. It's the one thing they share, and a legislative body doesn't all agree on the issues that were playing a role in the text that was ultimately produced. The interpreters of law don't always agree. A Supreme Court panel doesn't always agree on the interpretation of law, but the one thing that all of these people with their disparate opinions share is the text in the law itself. And so I want to talk about that text and how linguists may be able to offer some help from time to time with interpreting that text. So how do we go about interpreting legal text? Well, again, much of this is a legal question, not a linguistic one. But obviously we have judicial discretion, that ultimately the power lies with the judiciary, judges, to make decisions regarding the meaning of the law. But we have a couple of things that have been proposed to help judges as they make these decisions. First, especially for textualists, there are linguistic canons of construction. These are essentially prescriptive rules that have been proposed to guide legal interpretation. So think Justice Antonin Scalia and his book on reading law and the canons that were proposed there and many other places. And these canons, in one form or another, have been around for centuries. They're prescriptive, much like a style guide or prescriptive grammar. They're ultimately rules of thumb for how the language of the law should be read and interpreted. More recently, it's been proposed that corpus linguistics could offer some help. Corpus linguistics is a descriptive approach in contrast with the prescriptive canons of construction. And essentially the argument is that a corpus, which is a large body of naturally occurring texts, can be investigated in order to produce data that could inform legal interpretation. So again, a corpus is a sample of language, often very large, principled in its design, aiming to be representative of some larger population of language use. And then, of course, linguistics is the study of language. And in corpus linguistics, we apply linguistic constructs, theories, methods to investigating linguistic questions in this corpus. So corpus linguistics relies on automatic methods as well as manual methods. Often a computer is used in order to automatically identify patterns, and then the linguist comes in order to filter through and often interpret the language that exists in the corpus, the patterns that were found using those automated methods. And it's crucial that we understand that both of these play a role. Any method that uses a corpus only in an automated way, that disregards a linguist and linguistic questions and linguistic interpretation, in my mind, is not corpus linguistics. I would call that computational linguistics. Corpus linguistics requires that a linguist plays a central role. Linguistics is done by linguists, not by computers. And then we also rely on both quantitative and qualitative methods, meaning there are often numbers that play a role in order to quantify patterns, but the qualitative interpretation that comes with relation to those numbers is crucial. The linguist has to play a role. The end result of this is linguistic trends, patterns, and norms that we get from the corpus that we believe represent the actual language use that is produced in the real world. Crucially, the goal is to aid, not to replace, judicial decisions. So anytime corpus linguistics might play a role in legal questions, it should never be to replace the crucial role of the judge, but only to be helpful. Much like a dictionary has been helpful for judges and other ways of looking at language outside of the particular case and the particular statute at hand, linguistics and corpus linguistics may be able to offer some insights that could guide judges as they make important decisions. So one question that I've been involved with is what if we use corpus linguistics to evaluate and potentially improve on the canons of construction? So we have these prescriptive rules about how language should be interpreted in the law, but many of them are questionable. They were developed by legal scholars and possibly judges in an effort to be helpful, and yet without empirical data to guide the development of those statutes, we have to wonder how valid they are. Do they actually represent reality? Is this really how we should be interpreting the law? So there have been studies that I've been involved with related to surplusage, as well as the series qualifier and last antecedent canons. Interestingly, Justice Alito made some comments about this very intersection between corpus linguistics and the canons of construction just a few weeks ago. He said the strength and validity of an interpretive canon is an empirical question, and perhaps someday it will be possible to evaluate these canons by conducting what is called a corpus linguistics analysis. That is an analysis of how particular combinations of words are used in a vast database of English prose. And it's exactly these types of questions that we've attempted to answer along with some other scholars. Today, I want to ask a slightly different question. What if we used corpus linguistics to identify and potentially eliminate linguistic questions before they even arise? So many of the big questions in statutory interpretation come down to language that is ambiguous or, with relation to surplusage, potentially redundant. And huge amounts of money, large amounts of resources are spent trying to get to the bottom of what the law means and how it should be interpreted. What if there were a way to use corpus linguistics to ferret out those issues before they ever go to court, before they ever become a matter of legal dispute? Again, I'm exploring. I'm asking a question that maybe won't end up having a useful answer, but bear with me while we explore today whether we could potentially accomplish this goal. So the canon against surplusage, according to Scalia and Garner, says if possible, every word and every provision is to be given effect. None should be ignored. None should be needlessly given an interpretation that causes it to duplicate another provision or have no consequence. Essentially, what we're trying to deal with is redundant language in the law. Or ask the question, whether words, phrases, or statutes, or sorry, entire provisions within statutes are redundant. It won't be surprising to this audience to know that when potential surplusage exists, that the two sides in an adversarial case align themselves with two different interpretations. One usually says these two terms or these two provisions are not redundant and should be given an independent meaning of each other. And the other side says, no, they are redundant and only a single meaning should be assigned to both. So a couple of examples. One is Moscow versus United States. Part of this case hinged on whether the terms in falsely made, forged, altered, or counterfeited were redundant with each other. Is there really a meaningful difference, an important difference between the word forged and the word altered and the word counterfeited? Or is this merely evidence of a belts and suspenders approach to legal drafting? Meaning, out of an abundance of caution, legal drafters add additional terms in order to cover their bases, cover as much ground as possible. Another example more recently is Facebook versus Degreed, which looked at whether store or produce covered the same concepts or not. So according to Scalia and Garner, sometimes drafters do repeat themselves. We have cases like execute and perform, rest, residue, and remainder, peace and quiet. They ask, when is peace not quiet? What satisfies execute but not perform? And according to these authors, we often see doublets and triplets, so series of words that are redundant with each other in the law. And it's just an example of flawed legal drafting. And according to these authors, it's very easy to identify these types of doublets when they arise. As a linguist, I don't have any evidence that's the case. I think it can often be very difficult to identify these semantics, and the question of semantic similarity and synonymy, potential synonymy, is a tough question for any linguist. And knowing for sure that two terms are redundant with each other or not is often a very difficult question to answer. So these authors make some recommendations. Statutes should be carefully drafted to avoid surplusage. General language is preferred over redundancy. And they propose that if legal drafters are incapable of ferreting out these redundant terms, they should hire editors to do this job for them. Well, I might add a fourth suggestion here related to my question, which is linguists, with the help of legal scholars, could possibly flag potential surplusage even before it becomes an interpretive problem. And I'm going to apply a bottom-up approach today to corpus data to see if we can identify potential candidates for surplus language before they even become legal questions. So we're going to focus specifically on doublets. These are often formulaic two-word phrases that contain semantically similar words. In linguistics, we would call these binomials. In earlier work with Justice Lee, we've tried to develop some quantitative methods for identifying or measuring potential surplusage in doublets. So we've looked at the question of formulaicity. How formulaic is the doublet? One way of investigating that is asking whether the two terms in the doublet could be reversed in order, or how frequently they are reversed in order. So you take something like execute and perform. How often do we say execute and perform versus perform and execute? Maybe a more obvious example of a highly formulaic doublet is peace and quiet. It probably sounds a little bit awkward to you to hear quiet and peace. I need some quiet and peace around here. And that's an example of a highly formulaic doublet or binomial that is unlikely to be reversed because of how formulaic it is. We actually expect it to come in a particular order, peace and quiet. We've also looked at semantic similarity. This is much more challenging. We've used a method called word-to-vec, which relies on methods in distributional semantics to essentially take a large amount of data and look at the context, the lexical context in which words appear, and to see how similar the contexts are for two words. So we would take the word peace and look in a large corpus at many different windows of context around all of the instances of peace, and do the same thing for quiet, and in a quantitative way, try to measure how similar those two contexts are. Are the words that occur around peace similar to the words that occur around quiet? It's an interesting method. I'll apply it today, but with a huge caveat that it's essentially a black box method. It's very difficult to know exactly what's going on under the hood. And while I think there's some promise here, Justice Lee and I have questioned whether or not this method can or should be used with legal interpretation. I think it may actually be more useful for what I'm going to propose today than it has been for questions we've asked previously. I think it might be more useful for identifying a bottom-up list of legal doublets that can be compared relative to each other, rather than taking a particular doublet and measuring its individual similarity score. More usefully, I think it's always important that we do manual coding of semantic similarity. Have linguists or legal scholars look at these and determine how similar that they appear to be. Okay, so I've recently been involved in a project with Margaret Wood where we have developed a corpus of US state statutes. This is a massive corpus that contains every statute from every one of the 50 US states. It has about 1.8 million statutes in it and over 400 million words. This is a lot of legal language, and all of it comes from state level statutes. Here's a quick snapshot of which states contributed the most words to the corpus. You see California and Texas contributing the most, and Utah and Arizona fall somewhere in the middle. So my goal is to see if we can use the methods that I've mentioned to create a legal doublet list. Now, I'm open to suggestions for a different name here. I don't want this to be mixed up with bad cholesterol we're all trying to avoid. But essentially, I want to see if we can use bottom-up methods to see if we can find doublets that exist in statutory language here at the state level, but this method could be applied to any corpus of legal language. To see if we can have these legal doublets surface so we can identify them, be aware of them, and potentially, and this is a pretty bold proposition, but potentially go back and revise the law to address these things, or preemptively establish that these are redundant terms or not, and define how they're different from each other long before these ever become difficult legal questions in a court. So I'm looking at binomials that contain noun followed by the word and or, and then another noun. Same thing for verb, and verb, verb, or verb, with same thing with adjectives and adverbs. So I'm going to produce 4 separate lists that contain these 2-word pairs that have to be matched for their part of speech category. I required that the binomials have to occur 10 times in our corpus of US state statutes. And then I measured things using a reversibility score, which is essentially the proportion of total times that the 2 words are used together, and divide the total times one particular ordering of the 2 terms was used by that sum. I'm also using word2vec. Again, still questioning how useful it can be, but I think it may offer us some insights here when we have a large number of doublets. It gives us a similarity score between 0 and 1, where 1 is the 2 words are the same essentially, and 0 is they don't share any context. So I started off by automatically identifying binomials that had high scores for both reversibility and for similarity. And then I did some manual coding to get some examples of binomials that possibly contain surplus language, or that I believe could be argued to have redundant meanings. So here's 10 of the top results for the noun and noun or noun list. The methods that I mentioned produced about 8,000 of these pairings. And these 10 that I'm listing here are examples that had high reversibility scores, high similarity scores, and that I also thought might be argued to have similar meanings. So what is an immunization that is not a vaccination, or vice versa? Again, you may have an opinion about this, but is it possible that another side in a legal case could make an argument for a different interpretation? What's the difference between newborns and infants? What about vehicles and cars? If a car is a type of vehicle, then doesn't vehicle and its meaning subsume the meaning of car? Kinds and types, are those different? Rules and regulations, duties and responsibilities, prisoners and inmates, laws and regulations, accident and collision, conversation and discussion. As a linguist, I look at these words that floated to the top using my methods, and I ask, is it possible that we could find ourselves arguing about whether the 2 terms in these pairs are redundant or independent? And I think it's not hard to see that these could end up being matters of dispute in a state level or US level Supreme Court case. Here's our verb list. Here we only have about 1,500 that came up using the methods. Earmarked and allocated, formulate and devise, impairs or impedes, corrected, remedied, supplying, distributing. All of these, I think, are suspect and could be questions of potential surplus language use. Now, in some cases, it's possible that a legal scholar would look at these terms and say, no, the law has a technical definition for those terms. It would distinguish between their meanings in some definition somewhere. And if that's the case, as a linguist, I'm not aware of that, but I think in many cases, these types of terms are not defined. There's no distinction made between them in the law, and invested parties aren't sure exactly what to make of the difference between the 2 terms. An even shorter list for adjectives: constant and continual, pollutant, contaminant, false, fraudulent. Again, some potentially similar terms here in these pairings. An even shorter list, only 90 came up for adverbs, but I think some of these are really interesting. Fairly and reasonably, just and right, clearly and conspicuously. For many of these, I went to a thesaurus and a dictionary just to see if those texts would make any distinction between these terms. And it's often the case that the one term is used as a synonym for the other term, or the one term is used within the definition for another term. Again, I question how useful thesauruses and dictionaries can be for these types of questions. However, I think that's a pretty important flag that lexicographers, experts on words, thought that these words were quite similar. Okay, so just to wrap up here are some of my own thoughts about the possible role of corpus linguistics in statutory interpretation. So I think there are times when corpus linguistics, its methods and the data that come from those methods could aid the judiciary in difficult interpretive questions. Again, I want to reiterate, not replace. No linguist has any interest in replacing a judge. But I think there are times when the data that we've been trained to produce using these valuable data sets might be helpful for a judge or not. But I think there are cases where we should at least see what we can learn from natural language data in a large database. I think corpus linguistics can provide language use data for questions of ordinary meaning, original meaning. What I've done today is looked at the canons of construction and trying to apply a descriptive linguistic method to these prescriptive legal canons. Coming back to the statutory triad, there's a separation of powers between the legislative body and the judicial body, and all they share is that text. I don't think it's the responsibility of the judiciary to tell the legal drafters how they should be drafting texts. I also think I don't think it's the role of the legislative body to tell a judge when a question arises, here's what we meant in the law. I think that there's a reason we have separation of powers in our government, and to encode the meaning of laws in statutory text is an important aspect of our government. What I'm wondering here is if a third party, namely linguists, could come in and be helpful potentially to both of these two bodies. There isn't a separation of powers between linguists and legal drafters, or between linguists and judges. There's seldom a conflict of interest. Most linguists are descriptivists and purely interested in trying to get to the bottom of how language is used, what language means, and questions such as that. And just to wrap up, many of the things that I've proposed today are exploratory. I'm genuinely raising questions. Essentially, my goal is to ask, how can linguistics be useful? How can we help? And if the answer is you can't, with regard to certain questions of legal theory or legal interpretation, then that's perfectly understandable. I just wonder if there are times where linguistics could be helpful, and it's those questions that I'm feeling really excited about, and based on what we've been learning so far, quite optimistic about. I'll end there. Thanks for your attention, and look forward to hearing some questions and comments about what I've shown today. Thanks.
Thank you, Jesse. That was really interesting. I think that if you could hear the audience, you would probably be hearing a round of applause right now. There are some questions that have come in. I'll go ahead and address these to you. So this question from Samantha Stark. A potential difficulty with trying to identify when a word is redundant in advance is that the interpretation or potential interpretation of a word is very context dependent. So it's difficult to say that a word would always be redundant. What are your thoughts on this?
That's a great question. I think that's absolutely right. I think there are going to be times where we can't do anything preemptively or in advance. However, I think some of the doublets that I've produced on the lists are pretty obvious cases where, regardless of context, we should wonder whether the legal drafters were simply using a belt and suspenders approach, where their goal was, out of an abundance of caution, to throw in additional terms simply to cover their bases in future unforeseen circumstances. And it's that type of language that textualists such as Scalia and Garner have argued against. That makes judges' lives very difficult. To throw in extra terms that could become a matter of legal disputes, I think is problematic for a lot of reasons. And at least some textualists have said, let's see if we can get rid of those before they make their way into the law. But again, coming back to your comment, absolutely. I think so many of these questions are, they're all context dependent. But one thing that all legal questions share in common, regardless of whether linguistics can be useful, is that they're legal questions first and foremost. And at most, linguistics can only help potentially, but certainly not replace the role of legal theory and legal interpretation. So thanks.
Thank you, Jesse. Raymond Wixom wonders if you could define for us again word2vec, especially what the VEC means in word2vec.
Yeah, so essentially, word2vec is a machine learning algorithm that takes language, in particular in this case, the words that occur around a word of interest, and breaks that up into a many-dimensional space. So the vectors are vectors of language or words that occur in the neighborhood of these words of interest. And depending on how you set up the algorithm, you may have 300 vectors that are used for each word in order to try to quantify the words that occur in the neighborhood of the word you're interested in. Again, it's black box machine learning. We really can't peek in and say, okay, so what words did occur in the neighborhood of the word I care about? Too many dimensions, too many numbers. We're letting the computer do a lot of the heavy lifting. We end up with this similarity score that I've questioned. What does it mean? Is it valid? I've explored whether it's useful here, and I think it could be. But if somebody asked me, what does a 0.67 mean to you? Is that similar or dissimilar? I would say, honestly, I don't know. It's bigger than 0.66 and smaller than 0.68.
Okay, so VEC or vec means vector, apparently, right?
Yeah, vector. It's a vector space that the language is divided up into.
Here's a follow-up question by Abby Patti. What is the difference between these vectors and collocates?
The idea is the same. J.R. Firth said, "You shall know a word by the company it keeps." We're thinking about distributional semantics in both cases. Collocates are words that co-locate. They occur together. They're friends with each other in texts over and over again. And there's a linguistic canon related to this. I can't remember the Latin term for it, but essentially you shall know a word by its associates. Very similar, parallel to what we've talked about in linguistics. So collocates are not machine learning. They're much more simple quantitatively. And we essentially look at a word of interest and produce a list of words that occur in the same vicinity as the word we care about more often than we would expect by chance, using some statistical measure and some threshold of significance. What word2vec does is pumps this up with steroids, has the computer doing a lot more of the work, and in some cases takes the linguist out of the picture entirely. And that's what I'm really questioning here. But the idea is essentially the same. We're looking at the neighborhood where a word occurs and what words occur with it.
Thank you. And an interesting question from Austin McDowell. For purposes of identification, should your approach treat doublets differently if they appear in foundational or constitutional law rather than only in other statutes? Are certain doublets indispensably or unalterably redundant because they appear in foundational law?
I think that's a really good question. I haven't thought a lot about that. My first instinct would be to call Justice Lee, call a legal scholar. I've got a few on speed dial and ask them this question. I really don't know if from a legal standpoint, we should be treating different legal texts differently, my first inclination would be to say yes, because as someone who cares a lot about register at a very fine-grained level, in addition to what I've learned about nuances in legal texts, I would say we should be considering all of that at the very least. But I can't offer much more of an answer to that because, again, I'm a linguist trying to be helpful and trying to learn as much as I can, as fast as I can about how this all works. But I didn't go to law school and I haven't studied the law like many of you have for my whole career.
Thanks, Jesse. And now there's a question about the potential overlap between prescriptive and descriptive. So the question is about the prescriptive nature of canons. The language in canons frequently hedges, for example, in quotes, a pronoun generally refers to the nearest reasonable antecedent. Another guideline, post-positive modifiers normally apply to the entire series. And another one, if possible, every word or provision is to be given effect. So this language makes them sound somewhat descriptive. It almost seems as though the rules themselves are descriptive, but they are expected to be applied prescriptively. And the question is what you think about that.
Yeah, so this is something I've thought a lot about. And with you, Margaret, I've thought a lot about these questions. I think if you read some of these legal texts, like reading law from Scalia and Garner, you would think that they had data to inform the claims they were making. They use language that they'll say most of the time, generally, nearly always. And yet it's clear that there wasn't any time where they actually looked at patterns of language use. They're going off of their own intuition. And this is something that linguists have explored for decades. To what extent can a user of language intuit how language is actually used? And what we have learned from corpus linguistics over the last few decades is that as speakers of a language, our intuitions about language use are terrible. We do a really bad job of judging things like how frequently something occurs, or how widely dispersed a particular construction is. And so I think there is a role for these types of linguistic canons. What I'm arguing for is that we could use data to augment these canons to either offer support for or caution against their use based on actual language use data from appropriate registers. And I don't know what those appropriate registers are in every case. But I think before we're going to make claims like generally or always or never or most of the time, I think we need to have data to support that. We simply have no evidence that language users, no matter how much expertise they have, can even guess how general something is or whether something happens often or rarely. But a corpus can tell us those things with the click of a few buttons. And so I would say, I think the goal here is not to replace those canons, but to see if we can improve on them in some cases using data. And in some cases, we may find exactly what they say. We'll simply have empirical evidence to support it. In other cases, we may find the opposite is true. And I think I can find some examples in reading law where everything I've learned from a corpus during my career would raise serious questions about claims that are made. So.
Thank you, Jesse. I really appreciate that. There are a few more questions and comments, and I believe that you'll be able to type in your answers to those questions and comments later. But I want to thank all of you who have submitted questions and comments. Thank you, Jesse, for that really fascinating, interesting talk. Appreciate that. Thank you.